rich jurisprudence, interpreting and applying the provisions of the Convention regarding the delimitation of maritime boundaries. In case after case, the court has applied the three-step method, and it has now become standard practice. This begins with the drawing of equidistance line from the land boundary terminals. Fortunately, there are no technical, geographical, or other impediments to the construction of the equidistance line from that point. The second step of the process is the examination of the coastal geography for relevant circumstances that might warrant an adjustment to the equidistance line. In Somalia's view, there are none. The coastline is entirely regular, without any anomalous features, and there are no offshore features that distort the equidistance line. The final step of the process is to assess whether significant disproportionality results from the equidistance line. As we have shown in our written pleadings, there is none. There is thus no reason to depart from or adjust the equidistance line. In Somalia's view, the equidistance line is the equitable solution that the law requires. Kenya, of course, would have it differently. It urges the court to depart from the approach followed in every recent maritime delimitation case by adopting as the boundary a line that follows a parallel of latitude rather than an equidistance line. Kenya's main argument is that Somalia has acquiesced in such a line. Madam President, Somalia has never agreed or acquiesced that the boundary should follow a parallel of latitude. Our council today will elaborate on what Somalia definitively showed in its written pleadings. Maritime boundaries cannot, as a matter of law, be established through acquiescence. But even if this were possible under the law, it could not be the case here because the facts demonstrate that Somalia never acquiesced to Kenya's unilateral claim that the boundary was the parallel of latitude. Kenya's argument that the court should adopt the parallel of latitude as the boundary, even if Somalia never acquiesced in such a line, to reach this conclusion, Kenya would have the court dispense with the three-step method. Instead of that standard method, Kenya, in its own words, asks the court to apply a code parallel of latitude delimitation methodology, end quote. This is not a methodology that has ever been recognized, let alone applied by the court, or by any other international court or arbitral tribunal. We cannot help but believe that it has been invented by Kenya, it is made in Kenya, for the sole purpose of justifying its claim. It's an obvious contrivance that puts the cart before the horse. It presupposes Kenya's desired outcome, and it is highly prejudicial to Somalia. As such, it fails to produce an equitable solution as the law requires. Madam President, Kenya has not only claimed an extensive maritime area on Somalia's side of the equidistance line, but has also sought to exploit it. In particular, Kenya has authorized exploration activities, including seismic testing and drilling a well in the maritime zone claimed by Somalia. Somalia considers that these activities in a disputed area violate UNCLOS and customary international law. In its written pleadings, Somalia called for full reparation, including compensation for these violations. But we have come before this court in a spirit of peace and goodwill, seeking neither vengeance nor retribution. In this spirit, we have decided not to insist on compensation for past violations of our maritime rights. Madam President, members of the court, it is now my honor to lay out the organization of Somalia's presentations. Following me to the podium this afternoon will be Professor Alain Pellet. He will address Kenya's errors of law on the issue of acquiescence. He will show that it is not possible to establish an international maritime boundary by unilateral action. In the absence of an express agreement or a judicial determination, the establishment of a maritime boundary requires, at very least, tacit agreement. This, Professor Pellet will explain, is an exceedingly high bar to meet, and one cannot be met in the circumstances of this case. Professor Philip Sanders, QC, will then show why the facts do not support a finding that Somalia acquiesced in Kenya's unilateral declaration of a maritime boundary. The record is replete with contradictions in Kenya's position, including statements Kenya made in oral hearings before the court more than 4 years ago. Members of the court who heard Kenya articulate its preliminary objections in September 2016 will recall that Kenya took the view that the boundary remained to be established, not that it had already been agreed or acquiesced to. The argument that Kenya made before you then is directly at odds with the argument it makes now that a maritime boundary came into existence by virtue of Somalia's acquiescence. Having shown that Kenya's acquiescence argument must fail, Somalia's counsel will demonstrate why the boundary should be delimited by the court's standard, three-step method, and why, in application of that method, an equidistance line is the equitable solution here. First, Professor Alain Mayron will lay out the law applicable to the judicial settlement of maritime boundary disputes. In particular, how international courts and tribunals follow the three-step method to achieve the equitable solution mandated by the 1982 Convention. She will show why Kenya has proffered no plausible, let alone sufficient reason to deviate from the approach in this case. Next, Mr. Paul Reichler will explain how the standard three-step method leads to the conclusion that an equidistance line is the equitable solution here. He will show that the uncomplicated geographical circumstances relevant to this delimitation make the construction of a professional equidistance line unproblematic, and that there are no relevant circumstances meriting the adjustment of that line. He will also show that the solution produced by the adjusted equidistance line does not generate any disproportionality. And he will expose the fallacies in Kenya's approach to delimitation of the maritime boundary and the inequitable result that that approach produces. Finally, Mr. Edward Craven will show how Kenya has violated Somalia's sovereign rights and jurisdiction and breached its obligations under UNCLOS by authorizing and undertaking unilateral activities on Somalia's side of the equidistance line. That will conclude Somalia's first round. At the conclusion of Mr. Craven's presentation, our Assistant Deputy Agent, Mr. Mohammed Umar, will rise to deliver our closing remarks and read Somalia's final submissions. Madam President, members of the court, thank you for your time and courteous attention. I ask that now invite Professor Pellet to the virtual podium. والله ولي التوفيق، نعم المولى ونعم النصير.
I thank the agent of Somalia. I now give the floor to Professor Alampale. You have the floor.
Madame la Présidente, Mesdames et Messieurs de la Cour, bonjour. Madame la Présidente, le Kenya a voulu transformer ce qui aurait dû n'être qu'une affaire classique de délimitation maritime en une autre, centrée sur l'acquiescement qu'aurait donné la Somalie à l'amputation de 40% de l'espace maritime lui revenant dans la zone pertinente. Ce faisant, le Kenya torture passablement les principes juridiques applicables à l'acquiescement, ce que je vais m'employer à montrer dans un premier temps, et il sollicite très abusivement les faits pour les faire correspondre à cette vision assez singulière de l'affaire. Philippe Sands établira tout à l'heure les preuves sur lesquelles le Kenya prétend se fonder et il montrera que ces preuves ne justifient nullement ses revendications. Madame la Présidente, pour danser le tango, il faut être deux. Et les pas des partenaires doivent se refléter et se compléter. Il s'agit de danser ensemble, l'un avec l'autre, et non chacun de son côté. Eh bien, il en va de même lorsque l'on prétend fonder une frontière sur un acquiescement, un accord tacite, un estoppel ou des effectivités. Dans tous ces cas, la frontière ne sera établie que si la position univoque de l'un des États en cause correspond à celle univoque aussi de l'autre État. Et c'est à dessein que j'ai utilisé ces quatre expressions en vrac. Acquiescement, accord tacite, estoppel et effectivité. Non pas que je les croie équivalentes, mais le Kenya, pour sa part, les utilise de manière interchangeable dans un flou artistique. En réalité, elles n'ont pas la même valeur ni la même fonction. D'abord, excluons l'estoppel. On peut avoir des doutes sur la spécificité en droit international de cette notion technique propre au common law, mais sans vouloir entrer ici dans un débat théorique dépassant les limites de nos préoccupations actuelles, je me bornerai, comme la Chambre de la Cour dans l'affaire du Golfe du Maine, que je viens de citer, à relever que les mêmes faits étant pertinents, aussi bien pour l'acquiescement que pour l'estoppel, sauf pour ce qui est de l'existence d'un préjudice, on peut considérer les deux notions comme des aspects distincts d'une même institution. Il en est ainsi en tout cas au fin de l'affaire qui nous intéresse. Et je remarque que dans les deux cas, l'élément décisif est une acceptation claire et constante de la position de l'un des États par l'autre. Pour que l'on puisse parler d'accord tacite, il faut que cette acceptation, cet acquiescement, porte sur des prises de position, elles aussi claires et constantes, exprimées soit dans des textes express, dénués d'ambiguïté, soit à travers certains comportements convergents présentant les mêmes caractères et traduisant l'entente des deux États. C'est alors qu'interviennent les effectivités. Madame la Présidente, un traité suppose un négocium et un instrumentum. Il en va de même d'un accord tacite qui est une sorte de traité, même s'il n'entre pas dans la définition de l'article 2, paragraphe 1A de la Convention de Vienne. Un tel accord n'existe que si une position commune aux États concernés, c'est l'équivalent du négocium, c'est clairement manifesté et c'est le succédané de l'instrumentum. Or, dans notre affaire, il ne peut faire aucun doute que, faute de traité écrit en bonne et due forme, dont il n'y a évidemment pas trace dans le dossier de notre affaire, la frontière dont nos adversaires se prévalent ne pourrait exister qu'en vertu d'un accord tacite tel que je viens de le définir, établissant un tracé résultant d'accès ou de comportement du Kenya clairement et constamment accepté par la Somalie. Je rappellerai dans un premier temps qu'en matière de délimitation maritime, et à vrai dire en matière de délimitation tout court, tout unilatéralisme est exclu, du moins lorsque les intérêts ou les entitlements, il n'y a décidément pas d'exact équivalent en français, lorsque donc les entitlements d'autres États sont en cause. Et j'examinerai ensuite, dans un second temps, les conditions très strictes auxquelles l'existence d'un accord tacite est subordonnée, qu'il s'agisse du comportement de l'État qui serait à l'origine de l'accord tacite en question, ou du positionnement de l'État partenaire. Mesdames et messieurs les juges, en la matière, un accord est d'autant plus indispensable que l'on ne saurait admettre qu'un État s'empare de territoires ou de droits souverains appartenant à un autre État en l'absence d'accord. Il est également parce que, dans le domaine précis qui nous intéresse, la grande règle de toutes les règles est que la délimitation des espaces maritimes entre États dont les côtes sont adjacentes ou se font face est effectuée par voie d'accord, conformément au droit international. Autrement dit, qu'il soit express ou tacite, un accord établissant la rencontre des volontés des deux États concernés est indispensable. La notion d'accord unilatéral n'a aucun sens. Comme la Cour l'a relevé dans son arrêt de 1969 dans les affaires du plateau continental de la mer du Nord, l'opinion juris adhère depuis l'origine au principe selon lequel, je cite la Cour, la délimitation doit être l'objet d'un accord entre les États intéressés. Ce principe, a expliqué la Cour, relève du droit international coutumier. Les articles 15 et surtout 74 et 83 de la Convention des Nations Unies sur le droit de la mer l'énoncent fermement, et dans l'affaire du golfe du Maine, la Chambre de la Cour y a vu un principe, je cite, d'application générale, valable à l'égard de tous les États, ainsi que par rapport à toutes sortes de délimitation maritime. Fin de citation. Ce qui est important, ce n'est pas le caractère écrit ou non du traité établissant la frontière, mais les intentions des parties à cet accord qui, j'y reviendrai, doivent être claires et sans équivoque. C'est vrai aussi pour les accords entraînant un changement de titulaire de la souveraineté territoriale. Comme y a insisté le TIDM, aucun État, et je le cite, ne saurait arrêter ses limites maritimes de façon unilatérale, et celles-ci doivent au contraire l'être par voie d'accord, entre les États concernés, ou par le recours aux procédures de la partie 15 de la Convention des Nations Unies sur le droit de la mer, si les 10 États ne parviennent pas à un accord dans un délai raisonnable. Au détour de certaines phrases de ces écritures, le Kenya s'en est d'ailleurs déclaré d'accord. C'est le cas par exemple dans ses exceptions préliminaires, où il expose que, je cite, en anglais, The parties expressly agreed on a negotiated settlement of their maritime boundary. This was consistent with Kenya's legislations requiring delimitation by agreement with Somalia. It was also consistent with the provisions of UNCLOS. End quote. Comme le Kenya le relève dans son invraisemblable document daté du 22 février, c'est lui qui a initié une réunion avec la Somalie qui s'est tenue à Nairobi les 26 et 27 mars 2014 pour discuter de la frontière maritime sur la base du nouveau différend. Comme l'a fait remarquer avec un grand bon sens la Chambre du TIDM dans Ghana contre Côte d'Ivoire, je la cite, le fait que des négociations et échanges bilatéraux sur la délimitation d'une frontière maritime se soient tenus entre les parties indique l'absence plutôt que l'existence d'une frontière maritime. Si un accord est indispensable, et il l'est, il n'est dès lors pas douteux qu'essayer d'établir unilatéralement des limites internationales sans tenir compte de la position juridique d'autres États est contraire aux principes reconnus du droit international. C'est ce qui a conduit, vous avez dit dans l'affaire du plateau continental Tunisie-Libye, et c'est ce qui a conduit le tribunal arbitral constitué dans l'affaire des deux Guinées à refuser de, je le cite, prendre en considération une délimitation qui ne résulte pas de négociation ou d'un acte équivalent, conformément au droit international. Or, en l'espèce, la prétendue délimitation a été effectuée par un acte juridique relevant du seul pouvoir de la Guinée et susceptible, comme ceux qui ont été pris par cette même Guinée au nord et à la même période, de faire l'objet de modifications unilatérales. Fin de citation. Or, mesdames et messieurs les juges, c'est très précisément ce que le Kenya voudrait vous faire décider dans la présente affaire. Il vous demande de consacrer le traité unilatéral prétendument adopté par lui au prétexte du silence, également prétendu, gardé par la Somalie. Ceci revient à mettre en cause le principe fondamental de l'accord dont, je le rappelle, le recours à une délimitation par voie arbitrale ou judiciaire n'est en dernière analyse qu'un succès d'année. C'est que le Kenya est embarrassé par cette exigence d'accord. Il est conscient qu'il n'y a pas davantage d'accords tacites que de traités express fixant le tracé de la frontière et que les conditions très strictes mises par la jurisprudence à l'existence d'un accord tacite, comme d'ailleurs un acquiescement, et je vais y revenir, ne sont pas remplies en l'espèce. Du coup, il met la sourdine en ce qui concerne l'existence prétendue d'un accord tacite, dont il s'efforce de parler le moins possible en tant que fondement de sa prétention frontalière. Et il insiste précisément sur quelques comportements unilatéraux qu'il impute à la Somalie et qui constitueraient la preuve de l'acceptation, de l'acquiescement ou du consentement de celle-ci. Autrement dit, il se fonde sur des comportements purement individuels et toujours tacites, il ne s'agit que de silence, comme si ceux-ci pouvaient constituer des justifications autonomes établissant la frontière défendue par nos adversaires.
'24 of his counter memorial, and I quote, "The 1979 EEZ proclamation was thus both declarative and prescriptive and entailed rights and obligations for other states." This is indeed unilateralism in all its splendor. So even when it expresses itself in less of a caricatural manner, the starting point of Kenya's arguments is always made up of its own unilateral decisions. An example, amongst others, is in paragraph 206 of its counter memorial, and I quote, "First in 1979 and again in 2005, Kenya officially notified other states, including Somalia, that the single line of maritime delimitation with Somalia up to 200 nautical miles limit of the EEZ followed the parallel of latitude." End of quote. Kenya has not offered to proceed with negotiations in view of delimiting the border through an agreement. It is informing the international community of the delimitation line that it has decided on by itself. And such examples are numerous. The border having been established by the declarations made by Kenya, it is therefore up to other states to protest against this. I quote, "Kenya's case is that Somalia had a duty to react if it opposed Kenya's claim, and Somalia's prolonged silence therefore constitutes consent to maritime delimitation based on the parallel line. End of quote. As against the very fundamental requirements of the agreement, this position of Kenya justifying the creation of maritime boundary by one or several unilateral actions is legally untenable. By assuming as a premise an obligation to oppose a claim, Kenya is actually reversing the well-established presumption according to which unilateral acts of a state do not create obligations for third parties. The Commission for International Law recalled in the guiding principles applicable to the unilateral declarations of states in 2006, and I quote, "No obligation may result for other states from the unilateral declaration of a state. However, the other state or states concerned may incur obligations in relation to such a unilateral declaration to the extent that they clearly accepted, I repeat, clearly accepted such a declaration." End of quote. Silence is not enough. A positive manifestation of acceptation is required, as demonstrated in the arbitral award rendered by the King of Spain that was mentioned by the Chamber of the Court in the Gulf of Maine case, that it did not constitute, I quote, "a valid precedent." Acquiescence did play a part in that case, but in reaching that conclusion, the court relied on explicit declarations of Nicaragua and on conduct that had continued, I repeat, and on a conduct that had continued over a very long period, something which does not apply in the present case. It is not possible to lightly attribute to silence the radical effects of this silence for Kenya, and this is even more so when it concerns abandonment or transfer of territorial sovereignty and sovereign rights. Indeed, as Kenya mentioned in its second rejoinder, you have accepted in the Pedro Branca case that there was a change in the holder of sovereignty and that this could result from a tacit agreement, and I quote, "arise from the conduct of the parties," end of quote. But you also underscored that international law does not, in this matter, impose any particular form. Rather, it places its emphasis on the parties' intentions. And even further, in a passage that Kenya refrained from quoting, the court insisted, I quote, "critical for the court's assessment of the conduct of the parties is the central importance in international law and relations of state sovereignty over territory and of the stability and certainty of that sovereignty. Because of that, any passing of sovereignty of territory on the basis of the conduct of the parties must be manifested clearly and without any doubt by that conduct and the relevant facts. That is especially so if what may be involved in the case of one of the parties is in fact the abandonment of sovereignty over part of its territory. To accept Kenya's theory would be to admit that a unilateral declaration constitutes an injunction to react from the moment it is internationally notified, failing which the contravening party would be presumed to be bound. Madam Chairperson, an agreement is indispensable to delimit a boundary, whether it be a land boundary or a maritime boundary. And my colleague Philippe Sands will demonstrate that such an agreement, tacit or even more so express, is nowhere to be found in the current case. Distinguished members of the court, this is not to say that never before, regardless of the circumstances, has a delimitation resulted from a tacit agreement. But even if there is no trace of such in our current case, I would nonetheless add that from a legal standpoint, the conditions that are required for the existence of such an agreement for delimitation are particularly strict. As the case law points out, and that is well established, according to the very firmest wording of the court in its judgment of the 8th of October 2007 in the Nicaragua versus Honduras case, evidence of a tacit legal agreement must be compelling. The establishment of a permanent maritime boundary is matter of grave importance, and agreement is not easily to be presumed. End of quotation. And an absence of a written agreement makes it particularly difficult for the state invoking such a tacit agreement to prove its existence. In a recent case that you're familiar with, it is emphasized in particular the importance of a written document as proof of a tacit agreement. In Peru versus Chile, the court recognized the existence of such an agreement, but in order to do so, it based its conclusion on the pre-existence of a treaty recognizing the maritime boundary approved by both states. And therefore, the court deemed that the instrument was indeed a decisive element in this respect, cementing the tacit agreement. It was indeed an express agreement that provided the proof of a tacit agreement.
In the present proceedings, Kenya is not daring to claim at the moment that it requires a written proof of acquiescence, but has claimed that, quote, there is no question that a state opposed to the claims of another state, especially when it affects its sovereignty and sovereign rights, must protest if it wants to prevent acquiescence. End of quote. In other words, silence, interpreted as meaning an absence of protest, would apparently embody acquiescence when the claim or assertion of another party would be made publicly. According to Kenya, mere constructive knowledge is sufficient for acquiescence. Now, I don't really know what is meant by mere constructive knowledge, but I know that simple knowledge, rather uncertain in the current proceedings, of a position cannot equate to acquiescence. Contrarily to the assertions made by Kenya, it is a party which invokes a tacit agreement rather than that which denies its existence that it comes to prove the factual situation. The demand to the contrary would therefore put pressure on the party denying action to provide negative proof, which is almost impossible to do. It is up to Kenya, therefore, to prove via positive evidence that there has been consent, a clear agreement by Somalia to the boundary course invoked by Kenya. Kenya makes great play of the agreement which it seems to detect between the parties as regards the conditions which an acquiescence is supposed to meet, using the claim that both refer to the definition of the arbitral tribunal in the affair of the boundary delimitation between Ethiopia and Eritrea. But firstly, that is to overlook the fact that, as we have stressed in our reply, and as I have just reiterated, acquiescence is not a means of maritime delimitation which is adopted by UNCLOS. Even if one were to set aside this convention, which would hardly be acceptable, Kenya has mischaracterized the conditions which have been expressed by the Eritrea-Ethiopia Tribunal and bases itself on a very selective version of case law, which it interprets in a very controversial manner. The case law, the jurisprudence, is very clear and well established. As has been firmly underlined, acquiescence is not proven by an absence of reaction. It has to be evidenced by positive fact. Since 1969, in the cases relating to the continental shelf in the North Sea, the court has stressed that the court does not show opposition and cannot be presumed to have acquiesced on the basis of its silence alone, which can have a multitude of different meanings. It's no doubt that you said, in the result it appears that the court, that none of the reasons invoked is decisive. Each is ultimately negative or inconclusive. All are capable of varying interpretations or explanations. Even if the Federal Republic was not specifically opposed to the equidistance principle as embodied by Article 6 of the Convention, from a purely negative conclusion such as this, it would not be possible to draw the positive inference that the Federal Republic, though not a party to the Convention, had accepted the regime of Article 6 in a manner binding upon itself. In the Tunisia-Libya case, the first case in which the question of a tacit agreement arose, the court refused to accept that there was a tacit agreement on a definitive basis in the fisheries activities which were carried out on both sides of a line separating the banks of sponges of both parties, fixed by Italy in its municipal law and respected by Tunisia. Indeed, as you stated at the time, and I quote the court, the evidence of the existence of such a modus vivendi, resting on only on the silence and lack of protest on the side of French authorities responsible for the external relations of Tunisia. Equally, in the Gulf of Maine case, the chamber of the court had not upheld the claim of Canada based on the silence that was kept by the United States towards Canada's claims. And in the Libya-Malta case, Libya had explained, and I quote, that it had informed Libya of its intention to delimit its continental shelf by a median line, and that it had remained very silent in front of, when confronted with this Maltese request. It remained silent in the face of Malta's claim to such a delimitation, and Malta therefore saw this as proof of acquiescence by Libya, which prevented it, in law as in fact, from challenging the Maltese position. The court rejected this reasoning. The arbitral award, which was in the case opposing Newfoundland and Nova Scotia, unfortunately, this award doesn't exist in French, but I'll quote the English. In the maritime boundary cases, it has often been argued that the cases have, by conduct, established a particular line or consolidated some aspect of a maritime boundary. Such arguments have always been treated as admissible and been carefully considered. But it must be said that more often than not, they have been rejected, either because the conduct did not relate to the area in question, or was merely unilateral, or was performed vis-à-vis a third party, or was an exercise in self-restraint to avoid aggravating the dispute, or was equivocal. In this same award between Newfoundland and Labrador against Nova Scotia, the tribunal claimed that in order to establish a boundary not settled or determined by agreement has been established through conduct, it is necessary to show an unequivocal pattern of conduct as between the two parties concerned relating to the area and supporting the boundary. End of quote. And in order to reach this decision, the tribunal noted particularly that Nova Scotia and Labrador had expressly accepted the method of delimitation which had been taken on board. Kenya based themselves essentially on 4 cases, and I'm sorry to inflict upon you, Madam President, and distinguished members of the course, various case law, but In the case of Pedro Branca, which I mentioned a few moments ago on a similar matter, the case relative to the Temple of Prevear, the decisions that had been rendered in the dispute between Eritrea and Yemen, and the arbitral award of the 22nd of December 1963 concerning the interpretation of the Air Transport Services Agreement between the United States and France. Now, it's hardly necessary to discuss this final case, which neither covered a boundary dispute nor did it cover questions of territorial sovereignty. In fact, the decisive element which led the arbitral tribunal to decide on the existence of a tacit agreement was the fact that consent by France had been given within the framework of negotiations and echoed by a formal letter giving an express recognition in writing of acquiescence, whose logical interpretation was confirmed by the subsequent practice of the parties. In a similar vein, referring to Pedro Branca, the court had sufficient detailed evidence, and it was expressed rather than tacit, in the correspondence of 1953 between Singapore and Johor, noting that the Johor noted that sovereignty on Pedro Branca or Pulau Batu Putih did not belong to it. It did not have sovereignty over Pedro Branca, Pulau Batu. And therefore, these circumstances are only distantly related to the present proceedings. Furthermore, if one turns to similar cases, they have a very high threshold to establish the abandonment of sovereignty or of sovereign rights. But whereas the occupation of a land-based territory, even if one only deals with an island, is something tangible and easy to observe, things are very different when you're dealing with maritime effectivité. In fact, Kenya is the last country which can really accuse Somalia for not having protested against the encroachments on the sovereign rights of Somalia, which it was responsible for, when it insists, vocally, if not somewhat indulgently, on the help given to its neighbour weakened by civil war, including to try and ensure its maritime security. Kenya recognizes it in the voice of its own agent, who contradicts, indeed, the witness statement made by General Kwabana. And I quote, "Somalia," the Kenyan agent said, "has only recently begun to emerge from a long period of instability caused by civil war, humanitarian disaster, and widespread terrorism. In particular, I stress that, Somalia has no maritime enforcement capacity. Somalia has no maritime enforcement capacity," said the Kenyan agent. And indeed, it has been lacking in this maritime enforcement capacity until very recently. It's very difficult for Kenya to claim at the same time that Somalia lacked vigilance in silently allowing its sovereign rights to be taken over without response. The situation is very different from the situation in the Eritrea-Yemen 1998 case, in which Kenya seems to make great play of this award. I would add that effectivité are likely to become of greater significance when dealing with land-based boundaries, as there are no rules generally applicable in this field. Things are very different if one deals with maritime boundaries. The rules are clearly fixed, you need an agreement, and these rules cannot be overturned by creating a fait accompli. The analogy between the present proceedings and the temple is also not convincing. Unlike Siam, Somalia has not been involved in preparing jointly a map drawing up its maritime boundary with Kenya. Certainly in 2008, when the civil war was reaching its height of violence, it did receive a map which was drawn up unilaterally by Kenya. This map was annexed to a note verbale in which Kenya insisted for Somalia to agree with the maritime boundaries between the two countries. But this episode cannot be compared to the multiple occasions in which Siam very officially had received the maps that it would challenge 50 years later. Finally, and above all, one needs to note that, unlike Siam, Somalia challenged the course of this boundary in the Memory of Understanding, signed less than a year later, when the two parties agreed, and I quote, "The delimitation of the continental shelf between the Republic of Kenya and the Somali Republic has not yet been settled." This unresolved delimitation issue, I stress the words, between the two coastal states is to be considered as a maritime dispute. And once again, in the negotiations which were held in Nairobi in 2014 on the initiative of Kenya, the two delegations noted, and I quote, that after considering several options and methods, including bisector, perpendicular, median, and parallel of latitude, they could not reach a consensus on the potential maritime boundary line acceptable to both countries to be adopted, the potential maritime boundary line. Kenya has also based itself on an incidental sentence that it draws from the judgment that you rendered on preliminary objections in the present proceedings. You had stressed that Somalia had never directly notified Kenya of any alleged defect in its consent to be bound by the Memorandum of Understanding of the 7th of April 2009. But there is a gulf between insisting on the nullity of a treaty concluded between two states and tacitly carrying out maritime delimitation. And the doctrinal authorities, rare as they might be that are invoked by Kenya, are not really going to be of greater assistance. They are rather vague and general and have very little links to the case which is of current concern. I would, however, make one exception, which is the article of Herr Schlauterpacht on the sovereignty of submarine areas, both because of the eminence of its author and also the relative insistence with which our opponents have invoked it. But there is no need to tarry on it. The aim of this article, which was written in 1950, was to justify the lawfulness of American and British proclamations about the continental shelf, particularly by stressing the absence of oppositions in principle by other states, which did not prevent Lauterpacht from recalling that ab injuria jus non oritur, saying that one cannot stress too much in the present proceedings. So it falls to Kenya to prove, rather, not that Kenya remained silent, but that it had clearly accepted its unilateral definition of a claim, at least tacitly. And this acceptance has to be clear and devoid of any ambiguity. It has to at least be deducible without a shadow of doubt from its conduct. This claim of an acceptance does not leave any room for case law. It has to be perfectly clear and consistent, which is not just subject to maritime delimitation, but has been upheld, the case law that is, by dating back to at least the affair of the case of the continental shelf of the North Sea. As Charles Fisher has noted, or Charles de Visser has noted, one notification cannot give rise to a particular reaction. No reaction is possible. The addressee can keep silence. Whether one is allowed to conclude anything from this or not. One cannot oblige states to invariably protest against all assertions that political calculations can attribute to their silence. In fact, this kind of argument has never convinced international courts or tribunals when it has been called upon to rule upon a tacit agreement. None of them, not one. One needs a sufficiently clear conduct, sustained and consistent, to constitute acquiescence. Even when confronted with this kind of conduct, they have considered that a de facto line might be more in the nature of a provisional line or of a line for a specific limited purpose, such as sharing a scarce resource. Even there had been a provisional line found convenient for a period of time, this has to be distinguished from an international boundary, the court ruled in Nicaragua versus Honduras. The case law also indicates that the constancy of conduct of two parties, even if spread over a long time, is not sufficient to show an agreement. This is the result of a second strand of the continental shelf Tunisia-Libya case, in which Libya had based its petroleum blocks on blocks that had been drawn previously by Tunisia, and both states had rejected this de facto line in carrying out seismic exploration and for carrying out as well numerous drilling projects without any protest from the other party. Despite this conduct, the court nonetheless concluded that this line has been found by the court to be wanting in those respects necessarily to ensure their opposability to the other party. Equally, in the Libya-Malta judgment of 1985, the court rejected Malta's argument according to which the common line of border concessions and petroleum blocks was any pattern of conduct on either side sufficiently unequivocal to constitute either acquiescence or any helpful indication of any view by either party. In Nicaragua, Honduras, having noted that at periods in time the 15th parallel appears to have had some relevance in the conduct of the parties, the court refused to conclude that there was a legally established international maritime boundary between the two states. And more recently, in the case of maritime delimitation between Ghana and the Côte d'Ivoire at one of the ITLOS special chambers, the applicant state advanced a tacit maritime boundary which had been respected for 50 years and which was valid for all of the maritime areas covered by the parties. So as to do this, Ghana based itself principally on the oil practice of the parties and more precisely on the petroleum blocks granted by the two states, seismic surveys, drilling activities, and the maps of petroleum blocks. Ghana had also shown that the blocks that had been granted had been aligned on an equidistance line and that each of the parties had been confined the oil activities carried out by each of the parties had been confined to an area lying on the respective parties' side of the line. And each party requested and obtained the other party's permission before crossing this line in order to conduct seismic surveys. So despite the abundance, the concordance, and the variety of such evidence, the special chamber concluded that the oil practice, constant as it may be, was not sufficient by itself to establish a tacit agreement on a maritime boundary. It was also not convinced by any of the other proof that was invoked by Ghana, and the chamber therefore considered that the legislation adopted by the two parties, the requests submitted to the CRCS and bilateral exchanges between the two states did not allow one to conclude on a tacit agreement on a maritime or border boundary. So, Madam President, without wishing to encroach on some of the demonstration of facts that falls particularly to Philip Sands, I would like to note that so as to appreciate the scope of the conduct of Somalia, certain precedents seem to be of particular importance. This is the case, for example, in the cases noted by the ITLOS Special Chamber, Ghana versus Le Côte d'Ivoire, in which they noted that the parties agree that bilateral exchanges took place, but differ as to their exact content and significance to the present dispute. In the present chamber's view, or in the special chamber's view, the fact that these bilateral exchanges took place at all is relevant because it shows that the parties recognize the need to delimit a maritime boundary between them. So I think that one also can quote the ITLOS Special Chamber in saying that the subsequent bilateral negotiations at the Commission of Maritime Border Demarcation between 2008 to 2014 confirmed the parties' recognition of the absence of a maritime boundary between them. In Nicaragua versus Honduras, the court noted that the latter had accepted in an exchange of notes in 1977 to initiate the preliminary stages of discussions about the the definitive and marine and submarine delimitation in the Caribbean Sea Zone. And in a note of 1982, the Foreign Minister of Honduras concurred with the Nicaraguan Foreign Ministry that the maritime border between Honduras and Nicaragua had not been legally delimited. According to the court, referring to the Minky and Ekrahus case, this recognition should thus be taken as evidence of Honduras' official view at that time. Having reviewed all of this practice, including the diplomatic exchanges mentioned above, the court concludes that there was no tacit agreement in effect between the parties in 1982, nor a fortiori in any subsequent date, of a nature to establish a legally binding maritime boundary. The same also applies to the Bangladesh-Myanmar case that was judged before ITLOS, where the ITLOS tribunal concluded that a note verbal had been sent by Myanmar to Bangladesh, giving details of the fact that the parties had yet to delimit a maritime boundary. And this did not demonstrate the existence of a tacit or de facto boundary agreement concerning the territorial sea. Taking into account all of the above, one can conclude that a constant and a mutual practice over a long period of time is not sufficient so as to conclude on the existence of a tacit maritime boundary. Then, secondly, exchanges of notes, not notes sent with no reply, and the conduct of negotiations have considerable weight to bear in the judgment of evidence presented by the parties to the dispute. However, the silence kept by one of the states concerned is not sufficient to confer the status of a tacit agreement to a modus vivendi, even if over a long period of time on the ground or indeed on the unilateral decisions taken by the other state. And furthermore, the time, whilst it might play a certain role in establishing a tacit boundary, must be consistent with the circumstances of the case and the active conduct or inaction of the parties. Madam President, as I have said, this is not just a twist or a hip-hop which one can dance solo, but a tango, which is to be dominated by a pas de deux. Not only the conduct of the applicant state has to be constant, but coherent, but it must also be reflected identically by the conduct of the other party. As my colleague and friend Philip Sands is now going to demonstrate again, if you would be kind enough to give him the floor, his unilateral proclamations and the attitude of Kenya in general do not have either the significance or the constancy required in the present proceedings. And the same applies to the sporadic conduct of Somalia, which is invoked by Kenya and which does not have either the significance or the constancy which is required in the present proceedings. Distinguished members of the court, I would like to thank you for your attention. And, Madam President, if I can ask you to invite Professor Philip Sands to take this virtual podium. Thank you.
Thank Professor Alampale. Before I invite Professor Sands to take the floor, the court will observe a coffee break of 15 minutes. The seating is adjourned.
thinking